This is video lecture 4, making up for class on Wednesday, September 21st. Next in the book is Johnson versus Elk Lake School District. This is in the book to illustrate these special evidence rules that were passed by Congress in 1994 as part of the Violent Crime Control and Law Enforcement Act. And these are rules 413, 414, and 415, and they carve out exceptions for the admissibility of past crimes, past acts in sexual assault and child molestation cases. So to review, of course, we know that Rule 404B generally prohibits the admission of other crimes or acts to prove character, to show action in conformity with that character or trait, that propensity purpose. But these rules specifically override 404B's protections in these two categories of cases. So Congress came up with these rules on its own and then asked the advisory committee and others what they thought about the rules. And you saw in Ed Becker's Elk Lake opinion that the advisory committee vehemently and unanimously opposed these rules, but Congress let them stand anyway. So basically, in any case alleging a sexual offense, criminal or civil, prior crimes or acts of a sexual nature, bad acts of a sexual nature, can be admitted and used for any purpose, even to show propensity to commit sex offenses. Now, the rules also contain notice requirements, requiring 15-day notice that past crimes or acts are going to be put into evidence. And the rules define sexual assault and child molestation as well. So the prior act needs to be a crime. It needs to be something that could be defined as a crime, but it doesn't need to have ever been charged. And there, of course, doesn't need to be a conviction. It just has to be an act that fits the definition of some crime, sex crime. So early on, there was some confusion here with these rules about whether Rule 403 even applies to evidence admitted under these rules. But as you saw in the Elk Lake case, it does apply, even though it has to be viewed a little differently because of the nature of these rules leaning very strongly toward admitting this evidence. Okay, in Elk Lake, we have a civil case, so we know that Rule 415 is going to apply, not the other two, 415 about civil cases. So the plaintiff claimed here that she had been sexually abused by her guidance counselor while she was a high school student. She lost at the trial level and appealed, and she claimed that the trial judge erred in excluding evidence she proffered at trial of another crime alleged to have been committed by the defendant. Now, the alleged other crime, as you saw, was the guidance counselor's touching of a teaching assistant without her consent. The teacher's assistant would have testified, had the trial judge let her, that she went to another teacher's office to eat lunch when the defendant, who was also there, picked her up and threw her over his shoulder. She was wearing a skirt and his hand touched her crotch through her clothing. There was an issue whether the touching of her crotch was intentional or whether it was an unintentional byproduct of his juvenile horseplay there. But the plaintiff here contended that the prior incident was admissible under Rule 415. The appellate court disagreed and ruled that it was within the trial judge's discretion here to exclude that evidence. Now, one thing to note is the footnote on page 173 that is added here by the casebook authors. The prior version of Rule 415, which was in the place at the time of the Elk Lake case, stated simply that evidence meeting the requirements of the rule is admissible. It was the same with Rules 413 and 414 in their original iterations. But now they've been revised. They revised them just in the last 2011 revision to include the may admit language that I actually had underlined in the first slide in this PowerPoint. May admit rather than is admissible. So one question that came up in Elk Lake under the prior rule language was, well, did the rule mean that this prior act evidence is just flatly admissible, whether or not the trial judge considers it to be unduly prejudicial under Rule 403? So the question is, what did Ed Becker's panel say about this? Is this kind of evidence just always admissible? And we see that Judge Becker's opinion here holds that Rule 403 still applies. Now, in a portion of Becker's opinion not included in your book, he says that the legislative history indicates that Congress, in fact, expected Rule 403 to apply, despite what he calls the seemingly absolutist tone of the is admissible language. Again, remember that's not the current language of the rule since 2011. All right, but we saw that the court here upheld exclusion of the evidence in Elk Lake versus Johnson, and this brings up the question about the 403 balancing itself. So if 403 still applies, we can kind of intuitively know that it can't apply in quite the same way it applies to the other rules, since these rules expressly carve out this seemingly liberal admissibility regime for this evidence. So let's look at some of the major points here in the Elk Lake case, points that are made by Ed Becker and his panel, and see what factors apply. So Becker talks about how some courts and commentators at the time were saying, well, past act evidence under Rules 413, 414, and 415 should be assumed to be relevant and probative, and that the probative value is by definition not outweighed by prejudice. Therefore, it's normally admissible. Now, Becker obviously disagrees with that very simplistic view and says that probative value will, of course, differ from case to case. Just, because it's still not going to be a one-size-fits-all. The case facts are going to differ. And then he explains factors that he thinks should be taken into account when looking at probative value and doing this balancing. So he mentions the two major factors in the first full paragraph in the case on page 174. Number one, the past act must be sufficiently similar to the alleged offense at hand. And two, the past act must be demonstrated with sufficient specificity. In other words, it should be clear what the act was, and the evidence about it should not be too equivocal. Like the story here about the defendant hoisting the TA up into sort of a fireman's carry position on his shoulder with the crotch touching that may or may not have been intentional. I mean, even the TA herself here was equivocal about it. So these are the two major factors mentioned. But additional factors he mentions are from the Guardia 10th Circuit case, another 10th Circuit case. Number one, the closeness in time of the prior acts to the charge acts probably makes sense. Number two, the frequency of the prior acts. How many acts were there? How often were the acts committed? And three, presence or lack of intervening events. And four, the need for the evidence beyond the testimony of the defendant and the alleged victim. So here is sort of what I consider a fairly rare instance of courts explicitly talking about the need for the evidence being a permissible factor. All right, so as we saw, the court here, 10th Circuit in Elk Lake, determined that under Pennsylvania law, intentional touching of genitals, whether clothed or not, was a crime. So that was the threshold issue. And they said, well, it does fit Rule 413D's list of sexual assaults. That 413 sort of defines the sexual assaults for all of these rules. So they say, yes, it was a crime under Pennsylvania law. But there was doubt about whether the touching here was intentional, and the court clearly took that doubt into account in doing the 403 balancing. All right, so now this might seem a little confusing. With all the talk in the case about determining probative value, doing proper 403 balancing, you might have a question, well, wait a second. Does Johnson eviscerate Rule 415 then? Does Rule 415 even add anything to the prior law, or does it kind of bounce us right back to 404B? So the answers there are no and yes. No, Rule 415 is absolutely not eviscerated. And yes, 415 and the other two rules do still carve out a clear exception, even though 403 applies. So where the past act is demonstrated with specificity and is sufficiently similar to the acts for which the defendant is being sued, they talk about the congressional intent, that Congress actually intended that probative value of the past act be presumed to outweigh Rule 403's concerns. So that is still intact after this case, if the past act is demonstrated with specificity and is sufficiently similar. So again, we see this idea that the uncertainty of the evidence is a big factor to be taken into account in doing the 403 analysis, which is consistent with that footnote 6 in Huddleston that we talked about. Okay, so wait a second. Johnson versus Elk Lake is a Third Circuit opinion. Not every circuit has embraced this idea of Ed Becker's that there should be this presumption in a case where the past crime evidence is specific and sufficiently similar, but I do think the majority of circuits do agree with him, the circuits that have reached this issue. So the last thing I want to note here, though, is how generous this appellate panel was here in making assumptions about what the trial court did, which hasn't been the case in some of our other cases. Remember Judge Easterbrook's chagrin in the case about the chemist, where he was really slapping down that lower court for doing a bad job. And many appellate courts have raked trial court judges over the coals for not being explicit enough about their decision-making process, and especially when it comes to Rule 403, about not doing a clear and overt job of 403 balancing. It was the Beasley case where Judge Easterbrook was so upset with that trial court judge for the bad job he had done in explaining his balancing process. Judge Becker here is quite willing to give the trial judge the benefit of the doubt, as we see on page 175, for example. The plaintiff here had complained that the judge refused even to hold an in limine hearing on whether this evidence should come in. Apparently, he just ruled from the bench saying, "I think there's insufficient evidence that the touching was in any way intentional." Now that sounds a lot like a 104A analysis in which the judge's opinion about credibility reigns, right? But remember, under Huddleston, 104B is supposed to apply here. So what does Becker do? Becker bails the judge out and says, well, first, it was okay that the court didn't do the Huddleston 104B analysis about whether a reasonable jury would find the crotch touching intentional, because if a court finds the evidence would be too prejudicial, then that analysis isn't necessary. But then he goes on to say, well, the court apparently concluded that the probative value of the evidence was slight and was outweighed by Rule 403's concerns of prejudice, undue delay, waste of time, etc. This judgment appears to us to be sound given the equivocal nature of the testimony about intentionality. Now, Becker keeps saying it appears this and apparently that, and I think the judge did this. I sort of thought it appeared that Becker was apparently bending over backwards here to find that the trial judge had actually done his job. Okay, I have a couple of hypos now. In the case of Paula Jones, shown here, versus Bill Clinton, the plaintiff Paula Jones claimed that she had been sexually harassed by Bill Clinton when he was governor of Arkansas in an incident in which he allegedly had a state police officer bring her to the hotel room and then exposed himself and requested oral sex. So she sought in her discovery request in this civil case evidence about whether the president had had sexual contact with a White House intern, Monica Lewinsky. I'm sure many of you might be quite familiar with the Monica Lewinsky scandal with then President Clinton, right? So the question is, well, if this case had gone to trial, would evidence of Bill Clinton's contact with Lewinsky had been admissible under Rule 415? Okay, this is a little bit of a test on how much you remember about 415, but the answer to this is, well, no, because Bill Clinton's contact with Monica Lewinsky was not a qualified sex crime. There was consent. She was over 21. And remember, to be admissible under Rule 415, the evidence has to meet one of one of the sexual assaults that are defined in Rule 413. And that is, to be a sexual assault, the crime has to either be without consent or a sadomasochistic crime. But the evidence also refers here to Chapter 109A of the Criminal Code, which I'll tell you includes within its coverage sexual contact with children and sexual contact between a person in official detention and a defendant with custodial, supervisory, or disciplinary authority over the detainee, such as a prisoner and a prison guard. Okay, so that last question was about admissibility at trial. But could the evidence about sex with Lewinsky be discoverable even if it would not ultimately have been admissible at trial? Well, arguably, yes. Discovery might have turned up something that was admissible, such as maybe a modus operandi behavior or something that was admissible under 404B. And you know from civil procedure, discovery is allowed if it might lead to admissible evidence, even though that probably would have been vehemently argued about between the lawyers on both sides. All right, how about this one though? In that same case, Paula Jones versus Clinton, Jones wants to put in evidence that at a later time when Clinton was president, he had kissed and groped this woman here, Kathleen Wiley, who was also a White House intern, against her will in the Oval Office. Now, the evidence of this incident is hotly disputed by the president, and the accuser Wiley has made inconsistent statements about it. In fact, another person who talked to Wiley after the event testified that she seemed happy that the president had made a pass at her. So the question is, what result here? Would this be admissible under Rule 415? So let's do the analysis as if we were the judge here. So first, was it a qualifying sex crime? Well, let's assume if you believe the accuser, Kathleen Wiley, he touched her genitals against her will, we would say this was a qualifying sex crime. But there was a dispute about whether the accuser was believable, and Clinton hotly denied that anything took place. I mean, maybe if you get it past the first one, if it had happened, it would have been a qualifying crime. But we really have to look to the Rule 403 analysis to help us answer that question. So against admission here, Clinton might argue, thinking about those Elk Lake versus Johnson major factors. Number one, that the prior offense was too different to be probative. I don't know. I mean, he could make that argument. It does seem at least a little similar, though, so that one's probably a toss-up. But then secondly, Clinton would also argue that the evidence of the prior offense against Wiley was weak. So unlike Johnson, where the testimony of the other incident was equivocal on the issue of actually whether the touching was intentional, I mean, here, at least Kathleen Wiley's overall account of the incident was clear, as opposed to the teaching assistant. On the other hand, it was impeached and contradicted. Impeached because another witness said she seemed sort of excited about the attention, and contradicted by Bill Clinton himself. So I'm not going to answer the question of whether I would have let it in. You can answer that question for yourself. I will tell you that the case Jones versus Clinton actually ended up settling before determination of these outstanding evidence issues. Okay, so I told you that Rule 412, the Rape Shield Rule, had been adopted by most states, but unlike the Rule 412, these rules 413, 14, 15 have not yet been adopted by a lot of states. I think it's still a minority of states that have these. The last data I saw that were around 10 to 15 states had some form of both 413 and 414. Another 9 or 10 have some common law support for allowing prior crimes for propensity in this area. And even fewer have adopted something like 415 for civil cases. And at least 30 states have no rules at all like these, even though in some of them their state legislatures tried to pass this type of rule, and it was struck down by the state Supreme Courts. So these rules are very controversial. But let's see where California came out. Okay, I have an alert slide, so you know there are at least some differences. All right, so let's start with California Evidence Code 1108. California Code 1108 allows essentially the same things as Federal Rules 413 and 414, including a notice requirement explicitly in the rule mentioning that California's Rule 352 balancing applies. That's our version of Rule 403, remember. But California, in fact, goes even further and actually expands the type of criminal prosecutions in which prior similar crime evidence is admissible for straight propensity purposes. So, in addition to sexual assault and child molestation, we add possession of child pornography, employing minors for sexual depictions, and distributing obscene materials to minors. So our rule goes even further. Then California, of course, liked this idea of being able to freely admit evidence about past crimes so much, we added Rule 1109 that I talked about last week, which applies to domestic violence cases, elder abuse, and child abuse cases. So our domestic abuse exception, like I mentioned in class, very far out on the far end of the spectrum, because their past acts of domestic violence can be admitted even if the charged offense isn't domestic abuse. So it's also allowed in rape cases in which someone is accused of raping a significant other. And the prosecution isn't even limited to offering acts of domestic violence against the victim in the charged crime. So the prosecution can call other victims of the defendant to testify about past acts. Okay, they don't even have to be against the victim in the case. All right, the last one here on the slide, though, is that California does not allow this evidence in for propensity purposes in civil cases at all. So no counterpart to Federal Rule 415 here in California. Okay, the last thing I want to talk about in this unit is Roger Park's very interesting piece on page 176. So Professor Park did a more statistically nuanced analysis of this issue of whether sexual assault crimes should be the crimes subject to these extraordinary rules that get around the basic character evidence rules. So both Ed and Winkelried of Davis, who's another very prominent evidence scholar, and another law professor, Catherine Baker, they criticized Rules 413 through 415 by looking at absolute recidivism data of different categories of crimes and pointing out, well, rape has a much smaller recidivism rate than other crimes like larceny or burglary. So you see on the slide the absolute recidivism data they used. That is on the far left of the table. So for example, if someone was previously incarcerated for rape, he has a 7.7% chance of being rearrested for rape. And you see that the recidivism rates for burglary, larceny, and drug offenses are much higher. So Winkelried and Davis argued that, in fact, if you were going to have a special rule to allow in past crimes in a certain category of cases, it should probably be larceny or burglary cases. But Professor Park shows just one of the reasons he's probably the greatest living evidence scholar in the world by pointing out that, wait a second, the probative value of other crimes evidence is not determined by the simple recidivism rate for that crime, but rather by the comparative recidivism rate. That is, how much more likely a person who committed the crime once is to do it on a given occasion than is a person who never committed it, okay? Comparative recidivism is how much more likely is a person who committed this crime once to do it again compared to a person who's never committed it before. Because of course, for each new crime committed, you could say, well, if you start with a whole universe of possible suspects, some of whom may have committed a similar crime in the past, some of whom won't, right? I mean, that's sort of the universe of suspects you start with. Now, the key sentence in Professor Park's piece is there on page 177, and it's akin to talking about what we refer to as base rates, for those of you who are familiar with that concept in statistics. So here's the quote from page 177. When a given crime has a low incidence in the general population, the probative value of evidence of another instance of the same crime is going to be greater than it would have been if the crime had been more common, even if the recidivism rate for the crime is low. Okay, so Professor Park uses this great example of burglary by parachute versus regular old garden variety burglary. So looking at a similar example in the sexual assault context, let's say, suppose someone who commits rape before age 40 only occasionally does it afterwards, say 7.7% of them will, but that those who do not commit rape before age 40 virtually never do so afterwards. So in that case, if you have a rape case with an over 40 rape defendant and you have evidence that he committed rape before 40, that evidence has substantial probative value. So Professor Park does some great calculations for the table on page 179, and I put those on the slide to help illustrate his point. So he says instead of looking just at the raw data there on the far left column, we should do some math. So again, looking just at the far left column, it looks like maybe prior rapes wouldn't be as probative as a prior burglary because of the absolute recidivism rate. But instead, now let's look at each group of arrests for new crimes and see how prior offenders compare to people who have been in prison for something else. So, for rape, a convicted rapist is 7.7% likely to be rearrested again for rape. But felons who were convicted of a different crime are only 0.76% likely to be arrested for rape. Very rare. So doing a little math brings us to the third column here on the slide. A convicted rapist is therefore 10.1 times more likely to be arrested for rape than any other felon. And if you compare convicted rapists to the general male population, now you see a convicted rapist is 163 times more likely than an average non-felon to be arrested for rape. Now it's starting to look much more probative, right? And if you do the same calculation for, say, larceny, which, as we saw, has the highest absolute recidivism rate, you see that, in fact, a lot of felons who committed other crimes before are likely to get arrested for larceny once they're out. In fact, 19.65% of them, as compared to 33.5% of convicted larcenists. So that ratio then is much less powerful for larceny. Someone previously convicted of larceny is only 1.7 times more likely than an average felon to be arrested for larceny. And the ratio comparing larceny convicts to non-felons in the general population shows that the larceny felons are only 19 times more likely than any of us in this room to be arrested for larceny. So as seen in this light, there's definitely support for Professor Park's analysis that in fact past sexual assault evidence is much more probative than evidence of past larceny or burglary crimes. On the other hand, even though we don't have those data on this table, Professor Park talks about the fact that the comparative recidivism rate for murder is even higher than for rape. Yet, of course, we don't have a Rule 413 for murder cases. Now, Professor Park personally actually believes there is a special need for 413 type evidence in acquaintance rape cases, where so much depends on the word of the victim versus the word of the defendant. And when an alleged victim and a defendant had a prior relationship, it's much harder for juries to find non-consent. But if the defendant has past allegations or convictions, then it would tend to make the alleged victim's account more believable. So Professor Park actually thinks that 413 kind of rule actually makes sense with acquaintance rape cases.